टीचर हैं, हर मामले में जो है पार्टिसिपेट करते रहते हैं। आप जो दूसरे पार्टिसिपेंट्स आए हैं, नोमानी, शिखा कंबोज, योक्षा संगोला, आर.के. शर्मा, आप सभी का इस इंटरनेशनल सेमिनार में वेलकम है, स्वागत है, अभिनंदन है, वंदन है। इस जो आज इंटरनेशनल वेबिनार हो रहा है, इसके लीगल इफेक्ट हर क्षेत्र में पड़ने हैं, चाहे इंटरनेशनल लेवल पर हो, चाहे यूएनओ का। मेरा अपना विचार है कि हो सकता है कि जो सिक्योरिटी काउंसिल है, यूएनओ है, उसके रिकॉन्स्टिट्यूशन पर भी जो है विचार करना पड़े, क्योंकि ये जो बीमारी आई है, महामारी आई है, चाइना के अगेंस्ट अधिकांश जो है राष्ट्र जो है स्टेट्स आएंगे, और उस समय जो है इंटरनेशनल लॉ में भी चेंजेस होंगे। नेशनल लॉ में चाहे कंपनी लॉ हो, चाहे लेबर लॉ हो, चाहे कंज्यूमर प्रोटेक्शन एक्ट हो, क्रिमिनल लॉ हो, सब में जो है चेंजेस आने हैं इस महामारी के कारण। आप सब जो है इस उसमें आए हुए हैं, आप सबके स्वागत में दो श्लोक में पढ़ना चाहता हूं कि महाजन संसर्गा कस्यो नधिकार का पन पत्र स्थितम तोयम तत्ते मुक्ता फलश्रियम। For whom is the company of great people not beneficial, even a water droplet when a lotus petal shines like a pearl. दूसरा श्लोक है चंदनम शीतलम लोके चंदनादपि चंद्रमा चंद्र चंदन योर मध्य शीतला साधु संगति। Sandwood is pleasant, moon is more pleasant than sandal, but company of good people like you is pleasant than both moon and sandal. Thank you very much.
Thank you, sir.
Thank you so much, sir. First, before taking any time, and I believe in informalism. So let me invite Professor Balraj Chauhan, sir, in a very informal way, the way he wants. Sir, it's been 5 years here I have been teaching. It's been almost 9 years I have taught in this university. I must tell you that there is not a single day in the faculty room that your stories, your talks, your inspiration to other teachers is not being discussed. I do not think any teacher in my university, in my academic life, has been more discussed, more heard, more listened, more admired than you. At least in my university, I could say that. There is no introduction enough for you. So, sir is with us. Sir is a Vice Chancellor of Dharmashastra National Law University. Sir has been a Vice Chancellor of RMNLU. Sir has been an alumni of this faculty. Sir has been the backbone of this faculty. And with these words, I welcome Sir for his address. Thank you so much, sir, for coming, accepting our offer, and blessing us. Thank you, sir. Over to you, sir. Over to you, Balraj, sir.
Thank you very much, Panchrishi. I consider it my proud privilege, honor, that I got invitation from my own alma mater. And you can imagine how emotionally charged I am today. To see you, to see faculty members, to see Harjot, and all others who have joined on this international webinar. So I will say that I would like to address Professor C.P. Singh, faculty members. I know any might be listening, Dr. Rakesh, Anand Vishkarma, Anurag, Ashish, and Vinita, Varun Chachar, Kamal Ahmed. There are many, all of them, P.D. Singh, and really it's a exciting movement for me, to connect myself with you online, even online. And the pleasure is doubled when I saw the Harjot. It was doubled when I saw the Harjot, and I'm going to interact with him. And again, I'm very happy to know that he is the director of the Triwood Law Practice Limited, Baringam. He was intelligent, and I was knowing that he will do something very big in life, because he is the son of a worthy father. His father, Dr. Gurmeet Singh, was a good friend of mine, and he was in the medical fraternity, senior superintendent of the King George's Medical University. Previously, it was King George's Medical College. So I'm having a lot of memories, nostalgic memories of my stay in Lucknow University, law faculty, KGMU, because I got many opportunities. And I remember my associates, because I know now Lucknow University, you see, I say that the law faculty, great storehouse of learning, a great storehouse of learning and training of people, training of the people who are men of thoughts, who are men of actions. And I say that you have said that for the last 50 years, no, since the inception of the Lucknow University, law faculty has been pioneer, and we people, and you are carrying the legacy of Dr. V.N. Shukla, Dr. R.U. Singh, and when I joined, then Dr. Avtar Singh, Dr. Pramod Kumar Dwivedi, D.B. Avasthi, Surya Kumar ji, Ashok Srivastava, Professor R.P. Singh. So you name the person. So, and even today, faculty members like you, Varun, and seniors like Anand, Muhammad Ahmad, Kamal Ahmad. So I'm having high expectation. I always say that the law faculty of Lucknow University is very vibrant. And I always say that law school is not a place only for learning. It is about thinking and thinking and thinking. And if you can force your students, if you can force the people who are in to think, then things start moving. And I congratulate Newport Association of Lucknow University. I congratulate team. I congratulate you. You will not realize what a pleasure I am deriving in seeing you as my colleague. And when you told me that scholarship has been conferred on you for 3 years and you will be doing some research on the health laws, and of course you deserve it, and I congratulate you for that also.
Thank you so much.
So as I say that law faculty is a place for the conservation of knowledge, for the creation of knowledge, for the dissemination of knowledge, and for creating the knowledge makers. Harjot Singh, he has got knowledge.
No, sir.
And
Hearing from you, sir.
yes. I know. Modesty, but really, I appreciate, and that is beauty of a university. And here the responsibility of the teacher, because if they perform duty, then certainly they will be failing in their objectives. I can only say, I am thankful to the organizers for providing me this wonderful opportunity to interact with you all, and I will remember this day and date throughout my life, because I'm here in Jabalpur for the last 2 years. Though I have visited faculty several times, but I was not getting the opportunity to interact with you. Mentally, I was connected, but virtually also today I'm connected. So it's a big thing for me. Thank you, Panchruchi. Thank you, CP Singh, for providing me this wonderful opportunity. Today, you see, we are the main theme of the conference is aftermath of pandemic, Law 2. And the discussions, as you said, that we have to give the foundation. How law is changing during this period and after this period. But friends, I can only say, I was just listening news just before. And there was a news that there is a death every after 20 minutes in Delhi. There is a death every after 15 minutes in Mumbai. And the pandemic is spreading like a wildfire. It is spreading like a wildfire. And government is making attempts. Everybody is making attempts. You are in UK, their government are also making their attempts. But the problem with our country is we are having huge problem. A country of 135 crore people. A country which has been given this responsibility, challenge to look after each and everybody during this coronavirus 19 period. I think you will all agree with me that it's a big challenge. And this coronavirus is probably for the first time in the history is testing the might and courage of the people and the government, I will add, in the constitutional waters of the country. I'm not talking about the international situation, which I come later, because you all know that I am a basically student of criminal law. It's my domain, main domain. But today, the discussion I'm going to make, they are basically focused on constitution, because whether if I will talk about the offenses and penalty, that too are related with the constitutional law. And not only in my country, I think everywhere it is concerned with the relationship of the government with the people, because you know that the constitutional law is that discipline of law which provides the constitution, powers and functions regarding the different organs of government. And most importantly, it provides a relationship between the government and its citizens, its people who are living there. So that is the main focus of today's discussion. And I hope that the further discussions will also take on this particular issue. Why people are criticizing China today? Why people are criticizing WHO today? I think you all know that when the first case was reported, I think it was in the Hubei province, when this first case was reported regarding the COVID-19, and it was on 17th November 2019. And after that, first confirmed case of COVID-19, but China said that it's a unknown pneumonia case, and it was reported on the 31st December 2019. And WHO took one full 1 month to, but the Director General declared this coronavirus outbreak and the public health emergency of the international concern was given. They alerted the whole world on 30th January. You see, 1 month period is very long period as far as the spread of the coronavirus is concerned. And that's why the countries are after China. And I don't know what is the truth, because we believe the TV report or the print media report that it was done or not done. But one thing is very certain, had WHO taken the necessary precautions and they could have understand the areas to which it is going to affect, things would have been much better. Because in India, the first case was reported from the Thrissur district, Kerala. And it was again in January 2020. But the patient was a student who was studying in Wuhan, and he came back from China to India. Indian government I think it was the 11th March when the advisories was issued by the Indian government. By that time, the different news were coming. And in that advisories, they advise people not to assemble, and they issued advisories to the airport authorities. Anybody is coming from the foreign land, he should be properly examined, health advisory, this and that. They were issued. And also, the Ministry of Home delegated its authority to the Ministry of Health. But on 14th March, Union government asked the state governments to spend more fund for the management of the COVID-19 virus. After that, COVID virus started affecting the whole world. There was a crisis, and almost half of the population was going to be affected. And the Prime Minister announced Janta Curfew on 22nd March from 7 a.m. to 9 p.m. And it was only on, I think, March 24th when the government issued notification for the lockdown under the section 10(2) of the Disaster Management Act. One issue is raised nowadays, which I think all the students who are attending this particular webinar would like to know. Why the Parliament was adjourned prematurely on 24th March when there was a danger of the coronavirus. In UK and in some other countries, Parliament was in session. They were organizing its meeting physically, virtually also, and they tried to find out. So this is one thing which is raised, that why it was suspended prematurely when there was such a pandemic affecting the lives of the people. I think the countries where the parliament is supreme, for example, Arjot is coming from UK. In UK, the parliament is supreme. But in India, it is not parliament which is supreme. In India, all the constitutional teachers, I was asking Professor C.P. Singh today, who are the teachers who are teaching constitutional law. So I was told that Panchrishi, you are teaching constitutional law. I was told that Varun Chachar is teaching constitutional law. Muhammad Ahmad Saab is teaching constitutional law. Anand Vishkarma is teaching constitutional law. And my old friend Kamal Ahmed is also teaching constitutional law. So when such a good battery of the teachers is handling this particular subject, I hope that you might have discussed with your students the constitutionality of the Disaster Management Act 2005. Because in India, Parliament has been suspended, but the government was doing its work, discharging its obligations. Why? Because they were deriving powers under the Constitution and they were enforcing them. Of course, there are some fault lines or the fissures or gaps that I will come to. But as a constitutional law teacher, I think that the writ which has been filed in the Gujarat High Court regarding the constitutionality of the Disaster Management Act, students might have asked you, sir, you taught us that there is a distribution of power among the central and state, and the federalism is one of the essential element of the federal structure, and federal structure cannot be changed. So how all the power has been concentrated in the central government? Why they ordered without taking into consideration, because this particular decision was not taken by the parliament, but this decision was taken by the government under the Disaster Management Act 2005 for the complete lockdown. And that too, after that they passed several orders, and lockdown 1, lockdown 2, lockdown 3, lockdown 4. It was only after lockdown 4, I think you are calling law 2, and lockdown 1 started. They started relaxing the restriction, even though the cases are on the higher side, even though there are more deaths. Because I think that in the beginning, when Prime Minister announced the lockdown, and on that evening he said, "Jaan hai to jahan hai." At the time, for him, the essential thing was, the most important thing was how to save the lives of the people. And he was saying that we have to break the chain of corona. Stay inside, wash your hands, keep social distancing, and through it, we will be able to break the chain of corona, and then we will be able to overcome the problem. But they realized slowly and slowly, lockdown 1, lockdown 2, and they said life is more important. But by lockdown 3, I think again realization came. And the realization was, Jaan hai to jahan hai. Life versus livelihood. Cannot survive without livelihood. If life is important, then means through which life can be maintained, protected, nourished, and all economic activity. And I think this is the scene throughout the world, throughout the globe. They are trying to find out the balance between the life and livelihood. They are trying to find the balance, how the check and balances should be adopted so that both the things may go on. And but one thing comes to my mind, and it is because thank you, Panchrishi, you forced me to think. And believe me, I was thinking that as far as our constitutional arrangement is concerned, we are having 3 organs: legislature, executive. And when the parliament is not in session, that means one limb of the government is non-functional. And we are fighting with 2 limbs, executive and judiciary. Again, executive, you see, I don't know whether your students have discussed with you or not, but here my students, sir, what do you mean by executive? It has been defined in the Constitution: President, Governor, Chief Minister. Well, sir, some are elected. President, Chief Minister, Cabinet Ministers, they are elected executive officers. Some are selected, Chief Secretaries, Secretaries, and others. And some are nominated, like governors. It's a composite, you see, gathering of the people within the head of the executive. So executive consists of elected, selected, and the nominated members. And this has been burdened. See, you will agree with me that today the executive is overburdened. They are looking after all the developments going on around them. And one thing more, because it's my personal understanding, because I'm teaching for the last many years and I'm meeting bureaucrats, because executive consists of bureaucrats also. So executive has become more dependent on the bureaucrats. But the bureaucrats of any country, whether it is UK, whether it is USA, whether it is Australia, they are not trained to innovate or to create something. They are trained to develop the yes culture, yes minister, yes sir, it will be done. And then they will try to find out the ways from the directions given by the political bosses, I will call them executive bosses, and something like that. So whatever gaps we are seeing in the governance, it is because of the lack of creativity. Because I always say, when the total lockdown was announced, we forget to remember about the daily earners, daily wagers, migrant workers, migrant laborers, persons who are living below poverty line. They were knowing quite well their PDS system is not good. And even then, when the Prime Minister said that We have to break the chain of coronavirus. Will it be possible for us to lock down? Bureaucracy stood up very efficiently, effectively. Yes, sir, we will break the chain. How we will break the chain? Sir, we will ensure that nobody will come out from his house. And how? And you know that the whole legal structure is stooled on three basic laws as far as this lockdown is concerned. I will be happy to know more from Arjot about UK. That in India, the whole lockdown laws, or you see nowadays functioning, is stooled on three laws. Number one, Disaster Management Act 2005. Number two, the Epidemic Disease Act 1897, as amended by the ordinance on 22nd April 2020. And the third, IPC 1860. Again, I will give an emphasis. IPC 1860. Because in Epidemic Disease Act, there is a mention that who will flout the order passed by the competent authority, the prosecution will be taken against him under section 188 of the IPC. And this became a very important section of the governance, because today, just on 6th, we organized a seminar cum workshop with judicial officers and police officers physically. And there I informed them that in our country, more than 4.5 lakhs people have been arrested under section 188 in Tamil Nadu, more than 40,000 in Uttar Pradesh, more than 20,000 in Madhya Pradesh, and the number is very high. And it is, and how they have been arrested? By filing an FIR. This offense is cognizable. In some states, it is bailable. In some states, it is non-bailable. In Uttar Pradesh, Madhya Pradesh, Tamil Nadu, it is non-bailable. So, FIR was lodged that these persons have flouted the orders, and they have been taken into the custody and arrest was made. Ignoring the provisions of the CRPC as provided under section 41A, notice was not given. And even ignoring the mandate of CRPC under section 195, which provides that no court shall take cognizance of an offense under the 188 until it has been, until a complaint has been filed by a public servant. Now you see in all those cases, but there are long list of the Supreme Court cases, High Court cases. Supreme Court, I could find only 3 decisions on this issue, and the Supreme Court said that registering an FIR and starting the investigation is a different process, and taking cognizance is a different process. So there is nothing wrong if the police is arresting a person after registering an FIR and they are starting the investigation. However, courts is not competent to take the cognizance. But they have not. But in Jyotirmay Scindia versus State of Madhya Pradesh High Court said that filing the FIR under 188 and starting the investigation and after that making the arrest is void ab initio because of the section 195. So this is the issue, and I hope that even during pandemic or after the pandemic, this is one very important issue on which the Supreme Court refused to take cognizance when an PIL was filed by the Shri Vikram Singh, former DGP. But I hope that something will happen. Similarly, so what I was saying, that these 3 laws, they provided the basic legal framework for the governance in our country. Second point which is raised very frequently, and this point is related that this Disaster Management Act, it is not falling within the purview or the power of the central government, because health, medical laws and criminal law and health laws are having very old connection. We have applied criminal law for securing the safety and the security of the patient, even persons. But the question was whether the central government can intervene. Because as far as the public health, sanitation, hospitals and the dispensaries are concerned, under Schedule 7, they have been listed in List 2 through Entry 6. I think consular teacher might be knowing that this is within the ambit of the state list. But when I read and I got some help from my teachers, like my constitutional teacher, Ruchira Chaturvedi, and Shashti Chaturvedi. They gave me, no, sir, there is a entry in list 3, in concurrent list, entry 29, which provides prevention of the extension from one state to another to prevent the infection or the contagious diseases affecting man, animal, and plants. So, central government is having that particular power under the concurrent list. And I think we all know that if there is a conflict, then the doctrine of eclipse will apply and central legislation will prevail. So, this Disaster Management Act has been passed under the power which the central government is having. But there is one problem which I see, because when I was reading section 11.2 of the Disaster Management Act, it provides that, you see, under the Disaster Management Act, there are 3 authorities: National Disaster Management Committee, State Disaster Management Committee, and the District Disaster Management Committee. And all these committees are assisted by the executive authority. They are an executive authority which will execute the directions. National Disaster Management Committee made the national plan. But section 11 subclause 2 provides under the DMA Act that national plan should be prepared in consultation with the State Disaster Management Committee. I don't know, because I tried to find out, but I failed. Before passing the orders for lockdown 1, was there any consultation on it? Or it was announced by the central government one-sided? Because afterward there were meetings, chief minister's meeting or some meetings, and it is also provided that the state disaster management committee can make their state plans in accordance with the directions given by the central government. So that is one issue, and I don't know such type of issues are prevailing in other countries, because USA is a true federal country. Every state is free to make its own laws related to lockdown. So in some states there was lockdown, in some states there was no lockdown. In UK there was no complete lockdown as I think, but partial restrictions were there. And because in UK and USA and Germany, even the sale of liquor falls within the essential services. So there it was available even during the lockdown period. But in India, there was a ban. And again, I will come to that. I will try to speak legally on that particular issue, whether the central government is having the authority to encroach upon the powers of the state government, because as far as the entry 8 in list 2 is concerned, it is only within the ambit of the state government. And the excise duty on fuel on liquor, they constitute the major chunk of the revenue collected by the state government. And there was no sale of the petrol and diesel, and even the liquor shop were closed. State governments found it very difficult to run the show. These are the legal and the constitutional issues, which I think. But the first point, before I go further, I would like to make it clear that Section 62 of the Disaster Management Act provides. I would like to read that section so that you may understand what I am trying to convey. Notwithstanding, this section starts with this wording, notwithstanding anything contained in any other law for the time being in force, it shall be lawful for the central government to issue direction in writing to the ministries or departments of the Government of India, or the National Executive Committee, or the state government, state authority, state executive committee, statutory bodies, or any of its officers or employees, as the case may be, to facilitate or assist in the disaster management, and such ministry or department or government or authority, executive committee, statutory body, officer or employee shall be bound to comply with such direction. Bound to comply with such direction. So as far as directions of the government were concerned, they were having the binding effect. However, I say, most of the states didn't find time, or they couldn't make much exercise during lockdown 1 to prepare their state disaster plan. They are having, and they could have made their own plan. And if there was anything which they wanted to bring into the notice of the central government, then the State Disaster Management Committee could have referred that matter to the National Disaster Management Committee. Instead, I found, I don't know why this thing happens during this period also, politics started. Center is pressurizing us, center is doing this. I will not name the states because I don't want to say anything against, I respect people. And we are the student of law. We believe in decorum and decency. We want to say our things so nicely so that others, if they understand, may do. Or if they don't want to understand, then okay, matters will come before the court, and that day things will be decided. Because ultimately we say, one person asks, what is the law? A law, what is pronounced by the judge. Harjot, you believe in it? What is law? Law is what is pronounced by the judge. That's all. And that's why, because when we read the definition given by the Saman, law means set of rules enacted by the public authority in a legitimate manner and which is backed by the sanction of the state. Okay, it's good. But one philosopher, one jurist recently said, law is a word of many meanings. Sometimes it is slippery as a glass, and sometimes it is elusive as a soap bubble. So those who are attending courts, those who are practicing in court of law, they are facing the fire and thunder of the court each and every day. And that we have seen in our country also. During the lockdown, initially, the fountain of justice were locked. Then, partially opened. Then, thanks to the Chief Justice of India, matter started, or ball started running through the video conferencing. But even registry said, or the directions came from the judges, that only the important cases must be listed. You people are teaching Part 3 of the Indian Constitution provides fundamental rights to all the people. And the biggest fundamental right of every citizen is to avail the constitutional remedies. And constitutional remedies are available only through the High Court and the Supreme Court. And both were under lockdown, then afterward partially locked down, and even today they are under partial lockdown. Am I right or not? Whether an issue is urgent or not, who will decide? The sufferer or the person who is going to decide the case? These are the issue of the access to justice, and I hope that when Chachad and you and Anand Vishkarma are teaching constitution classes, and even in UK and other places also. Initially, when I saw the clippings from Italy, from France, people are not getting place for the burial, people are not getting enough space, what they deserve. And you see, government response, because what is happening in Delhi? People are not getting bed. Health services are not easily available. They have constructed more burial places. There was a news today कि वो 2 कब्रिस्तान, 2 शमशान घाट और बनाए दिल्ली में. So many so it's a question of human dignity. It's a question of so many rights, because theoretically we can discuss everything, and we are discussing everything. So in this situation, when we try to analyze and when you try to set the theme of the conference, I don't know from where I should start. Arjot, I hope that you will help me, and I am waiting for you also, because for me everything is important here. You can think, because whether it is, because we talk about the centralization of the powers in the hand of the state government, sorry, central government. And why we are saying so? Because they give example, sir, PM's Care Fund. Anybody who is donating money in the PM's Care Fund, it is allowed under as a CSR under the Companies Act. But if any donation goes to the CM fund or any other fund, it is not. Is it not a violation of the right to equality? Why it is? And the Corporate Affairs Ministry has replied, and I hope that to my mind, answer appears to be genuine. They said that CSR, okay, PM Cares Fund is there because it is permissible under Schedule 7 of the Companies Act. 135 provides for the CSR, and under Schedule 7, which has been given, it is there. But as far as the Chief Minister Fund is concerned, it is not covered. But the State Disaster Management Authority Fund is covered under Schedule 7. So why you don't create that fund? Why you don't take money? Why, if you want to avail or if you want to give the advantage of the CSR to the donors, then collect that money under that disaster management, state disaster management authority fund. But people are legally, they will not like to listen. And I have read so many articles on this particular issue. I have read similarly, when you talk about the centralization of finances, of course, the central government has done one thing. They banned the sale of liquor. And this is an important issue because I will say that I tried to find out some. First thing I would like to share. Panchrishi, you can tell me my time.
No, you were so blown. No, we were so carried away listening to you. There is no time limit at all for you, sir. Please carry on. Please carry on by your
Yeah, I
time.
want to listen Harjot also.
Sir, please carry on, sir. It's so enriching. And, you know, while you are saying, making points, because, you know, it's so exciting to hear you. And, you know, it's so much knowledge that we can get. So please carry on, sir. You know, I can speak tomorrow. It's not an issue, you know, but, you know,
No.
it's so
No. You are
but sir, the points you're saying is so important. It's so important, sir, because it takes us to the root of the issue.
Yes.
So the point that you're addressing, sir, is so important. It takes us to the root of the issue, and I think it's very enriching for all of us, sir. So please, sir.
Thank you, dear. So nice of you. So I was telling that Punjab Chief Minister Amarinder Singh, he was talking to a Punjabi news channel, and regarding the ban on liquor sale, he said, I'm quoting his words, "What has liquor got to do with the coronavirus?" he asked. Coronavirus spreads, he said, from an infected person's sphagnum or saliva. Now you freely allow to sale of vegetables, fruits, where these may have fallen, and which may be carrying the virus widely, but why ban a sealed bottle where none of these can get in? So this was the statement. But as I told you, that entry 8 of this is intoxication, liquor production, manufacture, possession, and the sale of intoxicating liquor. This is within the state list, entry 8. Within the purview, and the position was clarified by the Supreme Court also in the case of State of Jharkhand versus Ajanta Bottlers and Blenders Private Limited, which relies on Hari Shankar versus Excise and Taxation Commissioner to hold in unequivocal terms that the state government legislature is empowered to legislate on aspects of liquor trade, including but not limited to manufacture, storage, export, possession, and sale of potable alcohol, which is fit for human consumption. But the DMA gives extensive power to the union government, and they pass this particular ban. And we know how the Supreme Court has reacted in SR Mumbai and other case also. In that case, Supreme Court said that democracy and federalism are the essential features of our constitution and are part of the basic structure. The power vested de jure in the president but de facto in the Council of Ministers under Article 356 has all the latent capacity to emasculate the two basic features of the constitution. So I think under section 11 subclause 2, it would have been better if the central government would have consulted, because when they ordered the closure of all shops, establishment, trade, it brought to end still all the activities, all the economic activities, which has hampered the economic collections, revenue collections of the states in a big way. I think you have to find that we pray this type of situation never comes in our life again. But if, then such type of order should be passed after due consultation as provided under section 11 subclause 2 of the same legislation. We can discuss it further. Second thing which I want to raise here, that is a customized needs of states and uniform central response. I told you that the state failed to prepare their state disaster plan. But Central also failed to understand the customized needs of every state separately. They made one policy and they want to rule every state by the same policy. One policy doesn't fit. You can make researches on it, but I will say that you must read, because I'm talking in particular reference to the government of NCT of Delhi versus Union of India, where court unequivocally held that the union and the states need to embrace a cooperative federal structure. Dharmaji, you might be teaching this to the students.
Yes, sir.
I think this is a very important case of 2018. Collaborative federalism. But what we found that the orders were passed by the central government, ignoring that spirit behind. But I will say that we are fortunate to have a leader like Modi. He is one leader who stood like a stone in the toughest period which we saw in the Indian history. And he is navigating us well. But again, the thing is more dependent upon the bureaucracy. Wherever we finding the faults, they are coming from the bureaucracy side. Whether it is the labor department or the social welfare department or police department, in enthusiasm, in overactivism, because I say that this is first time in India that we have seen the human face of the police. We have seen different police, what we used to see before. We have seen the police taking the persons to the hospital. We have seen the lady constable assisting the women to give birth to the children, to the child in the ambulance. We have seen the police taking birthday cakes to the old people. And we have also seen them asking people to go for sit-ups and frog jumps and even caning. But nobody objected because everybody was sure that they are doing it for the sake of breaking the chain of the coronavirus. Ultimately, we are going to be affected by that. First time they got applause. First time they got bouquets, not bricks. And I say, as you are talking about the post-corona, let us try to keep the face of the police that way in future also. I will request Panchrishi and his team to think more how to organize training programs, how to sensitize them, how to take this human face more and more out. Same police and frontline warriors, and especially initially before the amendment of the Epidemic Disease Act, there were certain problems when there were attacks on the health workers. Because again, you see the human rights of the health workers, and especially doctors. So you are aware of the judgments given in the case of the central. This is the Central Research. Just a moment. Yeah. It's a case regarding the safety and the security of the health workers. And in that case, the Supreme Court has said that it is the fundamental duty of the state to protect the life and the health of the workers who are working in the hazardous industry. It is National Council of Research, Education Research, NCER, National Council of the Educational Research. It's a recent case. Yeah. So they gave specific directions, and all the rights of the health workers, they fall the confuse of this particular judgment. So ask the students to read them carefully. So when this amendment was made, when the ordinance was brought to amend the Epidemic Disease Act, the focus was on the safety and the protection of the health workers. They made, they provided stringent punishment, because before amendment there were section 188. If the offense has been committed under the section 3 of the Epidemic Disease Act, now after amendment, I you this Epidemic Disease Act also amended one in section 3A and B have provided that anybody who will show any violence or attempt to do violence against the health workers, they may be punished for minimum 6 months, maximum 7 years, or 3 months, or 5 years, and fine also minimum 50,000, maximum 1 lakh. So harsh punishment. And but the reality, you see, again, I feel disturbed when I see the situation in some states and the health workers not having the PPE kits. Doctors are not having the enough ventilators with them. They are not having the enough facilities. I remember one news which was published, I think, a month ago, where the 2 persons were taken to the hospital and there was only 1 ventilator in New York. 1 person was of 65 years of age and was 5 or 30. The old man said, I have lived my life. Please give facility to this young person. He must see the more strings. Salute to that person. But can you imagine the plight and the depression of the doctor who might be attending those patients? These are sensitive issues. And if you are having compassion, empathy, rights, okay, we read rights, and I can discuss in detail right to food, right to movement, freedom of trade, and Supreme Court also. Initially, they refused to intervene, but afterwards they took sumo action. They gave direction to the central government and also the state government, because that falls within the state list also. State government to make arrangements for food, for shelter, for health, for everything for the migrant workers. And we were moved to see that a mother is carrying her daughter who is sleeping on a roller suitcase. You might have seen, because every TV channel was running that clip again and again in their news bulletin. And it was difficult. It was difficult. So, I'm sorry, the other people are also calling for meeting. Today, I'm going to have meeting on the Criminal Law Reforms Committee, my first meeting. But for me, this is more important. I'm feeling so good with you people. And I've forgotten about the time, space. I think that we are all together. So I was saying that we can discuss, but I tell you one thing. All the teachers who are teaching you law, in post-pandemic era, you must start your lesson with the first thing, preamble of Constitution. Second thing, fundamental duties. Let us start from the fundamental duties. The only way to survive through this pandemic is follow the duties. Okay, I like the statement of the Kejriwal. This is no time for the confrontation. I will go what the LG is saying. Government was going to impose ban on the outside patient from the Delhi, but the LG refused. And when they came out from the meeting, they said, okay, this is not the time for confrontation. But you are seeing the condition of the Delhi hospitals. No beds, no proper facilities. The copies are lying unattended. No protocols are followed. I only pray, I only wish that let us survive, let us sail through this pandemic situation. It's a fire we have to fight, and hopefully, if we all will work together, we will be able to come out from this. I thank you all, dear. I don't know whether I have been able to set the theme of the international webinar, but according to me, there couldn't be any other theme, and the theme is Janvi or Jahanvi, Lord too for that. Thank you very much.
Thank you. Thank you so much, sir. Thank you so much, sir. It's overwhelming. It's enriching to all of us. I read it somewhere that a true law teacher is one who reminds in just 30 minutes all of the law books we have studied in 5 years. So you are that kind of a teacher for us, and we are so blessed. Like the way you have gelled constitutional law, criminal law, international law, epidemic act, disaster management act, IPC, and all of that blended together. That certainly had set up a theme, and certainly paved a way for us to go ahead with this webinar. There are so many questions for you. Like if I start reading them, like I have already got 12 or 13, so I'll be just filtering a few of them. If you have some time to answer 2 or 3 of them, shall I take 2 or 3?
Please, up to you.
Okay,
I want to listen, Harjot, before leaving.
No, sir, I want to listen more of you, sir. अभी तो बड़ा आनंद आ रहा है. It's so good, sir. मतलब, Dr. Sharma is right, sir. In just a little bit of time, sir, you have just taken the whole, you have discussed everything, about constitution, international impact, criminal law, and it's so enriching, sir. Really, it's very, very, it's a big knowledge booster for us also, sir. So thank you very much.
So nice of you. You are modest, and I know that you always praise.
But
I'm being honored.
I don't know whether it is allowed for an organizer to ask the first question, but I'll not let this golden opportunity go by any means. So I'll start with a question from my side first, and then I'll be taking some of the questions which participants have asked. So as you have rightly mentioned, that every emergency or every grave situation leads for the concentration of power, and that's what we are seeing as well. Hungary has proclaimed an emergency for an indefinite period. Harjot is there in Europe. He must be understanding what is going in through EU's mind when Hungary has imposed an emergency. Now, very nearby, Cambodia has imposed an indefinite emergency, and now with these 2 acts, it's kind of a very centralized blend of powers in center's hand. I'm not going for whether they are justified or unjustified, but do you see there would be a change in the constitutional waters, particularly regarding invocation of more lenient emergency powers? Like before it was, just before it was 44th Amendment, there was internal disturbance. If that kind of term would have been there would have been a very easily invocation of Article 352. Thankfully, because of 44th, it is not there. But do you think that globally constitutions will be changed in a way that there would be very much lenient emergency powers towards central government or towards centralization, so that whenever there is a kind of an emergency like this, center can take all the power or most of the powers in their hands? Because in almost all the emergencies and almost everywhere in the world, Trump is every day in his press conference, like, literally scolding certain governors for, like, they are not letting me use the powers. The same thing is going on with UK also changing their policy quite often. So do you think that there will be more centralization of powers post-pandemic in constitution? Do you think emergency provisions will be changing around the world, particularly in the constitution?
Very, very nice question, because evolution of laws, you are talking about the evolution of the constitutions in future.
Yes.
Example of New Zealand is before us. Only yesterday we witnessed that the New Zealand president was talking to the media and everybody. New Zealand is free from corona. And she said that it is because everybody acted as a team member. Everybody acted as a team member. Why we need emergency? You tell me about it. Why we need law? Why we have to use force to keep people inside? Are they not knowing? Either we have failed to communicate properly, whether it is USA, whether it is UK, whether it is Germany or Hungary. You see, Cambodia, Vietnam, China, you are not knowing anything about China. Whether there is an emergency or not, things are the same there. But fortunately, we are living in a democracy. We are living not in a democracy, but a democracy. We are talking about rights, and we question the actions of the government. We question why because I have full faith, because I believe in Kejriwal's statements. This is not the time for disagreement. Let us do what we are being asked to do. We will talk about other things when this situation will be over, and we will try to find out. But of course, you see, liberty is the most sacrosanct value of every institution. Less restrictions always help with the development. More restrictions, they bring anarchy, they bring dictatorship. And don't you think sometimes that the whole government is just working like a dictator? Nobody will allow you to speak. You go and see the cases through your legal aid program, because initially these migrant workers were not allowed to move. But after lockdown 2, they lost patience. They came out on the road. They started flooding the roads and the highways. And then the government realized their plight. Similarly, all the countries, because in UK, Harjot, I think 4 or 5 times they have revised their policies regarding the lockdown or the partial lockdown.
Yes, sir. Yes, sir. Every time, sir. Yes, sir. It's guided
Earlier,
by the
they were
science.
letting they were following the Swedish model. Let the virus run through.
No.
Okay,
The Swedish model.
funny.
Yeah, so the Swedish model is very different. In UK, there's a Coronavirus Act 2020, sir, and because of which they have to review it, and they're guided by the science. So they have done good job, sir. They have not done bad. But I'll expand upon it. But sir, yes, listening to you, I want to, because I'm just making notes of what you are saying, sir. So
It's good. So thank you, Panchrishi. Very good
Thank you
question
so much,
and very difficult. No, it's very difficult question.
No, sir, nothing is difficult for you. There is another pertinent question by Mr. Ashish Kumar. He has sent it to me that he's asking that
Ashish Srivastava or Ashish Kumar?
Ashish Kumar.
Our faculty member?
No, I don't think so, sir.
Okay.
He is asking that whether present government of India violating the 7th schedule of the Constitution, as they are not using National Disaster Management Act to enforce their decisions on state.
Read it again.
He's asking that whether the present government of India violate the 7th schedule of the Constitution.
No. In the 7th schedule, he must read entry 29 of list 3.
Yeah, I think so. And there is another question by Vikas Kumar. He's asking that another question by Miss Rashid Azmi, if I'm calling it right. That do you think that PM Care Fund should be brought under RTI, or will it be brought under RTI? What do you think?
I think you may bring it under RTI, because recently there was a petition before the Supreme Court. And when RTI activist was not given the information, he went before the Supreme Court, and the Supreme Court has given the direction to the central government to explain why this fund is not under the RTI ambit, because specifically it has been kept outside. It is more because of the politics. I am, as a vice chancellor, I am seeing, and you might be seeing, the misuse of the RTI. How many applications we are receiving each day regarding very small things, and PM can, once the COVID-19 is over, it should be audited. Not only audited through CAG. All the answers should be given to the people who want every answer, but not during the emergency, not during the pandemic. Let it be over. It should be a post-pandemic thing.
Yeah, thank you.
My personal opinion.
Yeah, the same question is from Ritika Srivastav too. There is one question, it's a very hypothetical question by Bhuvan Bhaskar. He's asking, how can an Indian citizen take a legal action and demand compensation from China? Or can they demand a compensation from China?
You are the international law expert.
We have kept a specific session for that too. I think it is on the third day, international legal point of view. Where can we make China responsible for the act?
One FIR has been filed, I was reading in newspaper, by one person against China. And you know that geographical boundaries, they create jurisdictional issues. But International Human Rights Commission, International Human Rights Courts, I don't know much about that, I admit. But there will be some remedy. If a person has actually suffered the harm, then he will be able to make the claim. And not against China, but through Indian government. They can claim from the Indian government also. Why they failed? Because you see, inevitable accident. Will it be an incident of the inevitable accident? If the government failed to take preventive measures in the beginning, whether cases may be filed, because these are the endless debates, and I think this is the time to focus more on prevention rather than for asking the, you see, damages or something like that. Courts are not functioning. Tell my friend that in India, at present, there is a lockdown. Only High Court and Supreme Court, they are partially open, and the rays of justice are coming, but it's a blurred situation. So hopefully we will prepare our case, try to find out more and more, ask your students to do research, that what will be the way to get a remedy out of it. But of course, it's a good question. Thank you. It's a very good question.
Yeah. I think as you mentioned, and as rightly, I'm also waiting for Mr. Harjot Singh for his wonderful words. But before that, let me just give you, let me just give and share all the audience the way you started it. You started it by quoting an incident in Wuhan, and you ended it on an incident that how can we can make China responsible. That's the beauty of a law teacher, that how he starts, he ends on the same thread. And in between that thread, there are several mini golden threads of constitutional law, constitutional governance, criminal law, philosophy, Epidemic Act, Disaster Management Act, CRPC. And we are really overwhelmed that the way you have covered all these areas. And believe me, it's one of the best theme setting that I've witnessed in my career, even though it's a very small career, but I have been through several.
Yeah,
and I believe that is one of the best of 60 minutes I've been through into an academic discourse. Taking on that point, sir, I really thank you from the bottom of my heart as your student, because I think once you're a student, always remain your student. You have a very emotional connection with all of them and with us too. Thank you from my faculty's side too. We are really overwhelmed. And sir, we all follow you like a Dronacharya. Somebody has been taught by you, somebody has not been taught by you. Because there are certain Arjuns, there are certain Abhimanyus too. Like I am a blessed one that I am an Arjun, that I have seen you, and there are certain who are Abhimanyus who might be here sharing a digital platform with us. So they are really lucky to get a digital point of view from your side. And no doubt that COVID situation has given so many pessimistic news, bad news, but one thing wonderfully it has done, it has bring us very close and without any cost. So it is really easy to be with you digitally, and I don't think it is as bad. Even though it would have been a brilliant thing to have share a coffee with you in the Dean's chamber, or namkeen with you, in your famous namkeen in the Dean's chamber, but it's not as bad. It's good. So thank you so much, sir, for your wonderful words. It's one of the best 60 minutes in my academic life. Thank you so much, sir. Now, on this note, I really welcome Mr. Harjot Singh, my alumni. He is the director of Twinwood Law Practice Limited in Birmingham, UK. Sir is an international human rights lawyer of a repute. I welcome you, sir. It's been an honor for University of Lucknow Faculty of Law to associate with you. We'll be taking, we'll be perceiving that we will have more interactions with this firm and also with you. Over to you, sir. Your point of view on how Law 2.0 is going to take place, how law services, law career, law teaching, law practice shall change. Your observations and your point of view, sir. To Harjot, sir, welcome you.
Thank you very much, Dr. Sharma. First of all, I'm so grateful for this opportunity. You gave me today. It's very emotional because first I'm coming back to my university, and I had the honor and privilege to be both Dr. Professor C.P. Singh Saabji and Professor Balram. And it's so emotional because when you listen again to Professor Balraj Chauhan Saab, and it comes to the memory, the old days, and you obviously you hold the Moot Court Society. Let me tell you, I was a participant of the Moot Court, and both my first selection was done by Professor Balraj Chauhan Saab, and he guided me, he pushed me. And then I went to, sir, if you remember, you sent me to Karnataka, Dharwad. So that was the first Moot Court. So, Professor, I'm really privileged because, I was taught by him. And being taught by a professor of like Professor Balraj Chauhan Saab, career. I wanted to be in the civil services. And, since I started going in the, on the Moot Court side, and because of Professor Balraj Chauhan Saab, Professor C.P. Singh Saab, my bent changed. I never did apply for even prelims for civil services, just went into practice. So, if you have got the good teachers, who, and you're right, Dr. Sharma, because a teacher is always your teacher, and you can only succeed. It's not about only knowledge, it's also about blessings, and the only thing I'm missing is, not touching their feet. Whenever I meet, I always touch the feet, because that's the culture. You have to be in the culture. Even here, I tell my daughter, I tell my colleagues, if you leave the culture, you leave everything. So culture is very important. And, if you don't respect your teachers, you're never going to be successful. Trust me. I've seen my colleagues, who had different views about the difficulty, and they have not done well. And, even if you're not so bright in law, but you need to respect, because, when the blessings come out, it works. So, on the topic, which is the legal opportunities post-COVID-19, I'm so humbled, because I've heard so much from Professor Balraj Chauhan Saab, I'm so embarrassed.
I understand it's really hard to speak.
You, Dr. Sharma, you have put me in a situation where I'm speaking after Professor Balraj Chauhan Saab. I just wanted to listen today, I would just listen today, 1 more hour, and would have spoken tomorrow, because it was so enriching. I've learned so much. Sir, I've really learned so much today. I made notes. If you look at my I've just copied everything. You know what you were saying? It's so because I'm running a project with Delhi University, one of the colleges of IP University, and there are 6 students who are internship in my office in Birmingham, EE training, and they're getting different public interest litigation. And so said to me, it would be so helpful. So thank you, sir. Thank you very much. Even today, I've learned so much in 60 minutes. Hope you would have carried for another 1 hour. I would have learned a lot. But if I may begin, sir, with your permission and permission from
please, I am listening. I'm waiting for that.
Yes, sir. To my dear students and distinguished faculty members and my lovely dear students, my heart goes out to the students of Lucknow University, because I'm from you. I'm from yourself. I'm part of you. Before I come to the UK, I'll briefly touch upon the UK side. We are lucky right now in 2020 when this all happened. In UK, we have got the most important minister in this country, the finance minister, we call it chancellor here, is an Indian, Mr. He's born here, but his father is from India. He's son-in-law of Mr. Narayan Murthy. And the way he has managed the entire pandemic, I would say, is phenomenal. He has got a lovely rating, and I will come to that. The home minister of this country, again, Preeti Patel, is Indian. So, we are very honored and blessed that even Indians are part of the top team in UK who are leading the response. And, I'm proud because, they're Indian at heart, and they're serving this country also, because, we have loyalty to UK and India, because all of us are here. But when I start on the legal opportunities, it's a stressful time for all of you. But as a law student, as Professor Sharma said in the beginning, every pandemic, there's an opportunity. I'm going to discuss in the next 40 minutes the opportunities for you. What is the opportunity for you post-COVID, and what are the changes you would see in the law? Because as Professor Balraj Chauhan Sahab said, there would be a lot of changes. And we have to go to the constitutional waters. We have to, dig deep, research. And, I would say, Professor Sharma, if, you being part of the Moot Court Society, you're heading that, make a legal clinic, encourage students. Because as what Professor Balraj Chauhan Sahab said, the right call. He made the right call. So we were very lucky. My parents are there. My learned teachers are there. My friends are there, and I'm very much concerned about India. My family is there, and so the Indian Prime Minister made the right call. It was Jaan hai to Jahan hai. That was the right call. But what Professor Balraj Chauhan Sahab said, that second aspect is, okay, Prime Minister can make the call, but bureaucracy. So we have to deal with the bureaucracy, because the rights are not being properly implemented. It's not a political party's problem. It is the problem of the bureaucracy. If the migrant labor has issues, I'm not going to talk about politics at all, because I'm not political. But I'm going to speak about the laws. And you as a law student should be concerned about how can you assist. So I'm setting this discussion on 3 parts. The first agenda is about humanitarian opportunity, because as a lawyer, you have to think about the society. Sir spoke about at length about constitution, the fundamental rights, fundamental duties. So you need to ensure how can you avail the humanitarian opportunities, and you can assist and help the poor, needy citizens of a country. The second agenda, I'll briefly touch upon the commercial opportunities. Once this pandemic is over, my dear students, there would be a lot of opportunities for you, and you have to be prepared for it, because there's going to be a change in contractual law. I'm already advising 2 or 3 companies in India who are requesting for advice on different aspects of the contract, because a lot of the contractual provisions would change, because 10 years before or 5 years before, we never thought about this is going to happen in 2020. The whole world is going to be shut down. So the contracts are changing, the format of contract is changing. The third, in the same commercial opportunities, I'm also going to briefly touch upon insolvency law. I think that's a very crucial law. Right now, the government has rightly, in my view, suspended the act because you can't make people bankrupt. But going forward, because of the commercial disputes, there would be a lot of creditors and debtors and there would be problems. So you need to be prepared as a law student, because tomorrow you want to qualify as a lawyer and you want to have the best skills so you can get the best jobs, you can get to the best chambers, and you can make a decent, good living from the opportunities you have. And the last one I would speak about is the e-filing. And like we are connecting today, it's wonderful. I never thought before this pandemic started that I would hear from Professor Balraj Chauhan Saab, who's so busy, you know, and we are so blessed to have him, Professor C.P. Singh Saab, and me coming to Lucknow University on a virtual basis. I go and give lectures here, but coming back to Lucknow Uni is the most valuable thing. I can tell you that. So e-filing, future of e-filing, and what Sir touched upon, the e-hearings, that's going to increase. Like in UK, I'll give you an example how it's increasing. So to set the motion, I'm going to speak first about the agenda first, which is the humanitarian opportunity. Now, with respect to the humanitarian opportunities, as Sir has spoken at length about the Disaster Management Act and the epidemic laws, which are pre-independence, but obviously there's amendment now. What I want to touch upon is really the key issues. And let's take an example of Delhi State, what Sir was discussing. You feel sad when you see people dying and people burying the wrong people. So, even the death is not getting the dignity. It's not any political thing. It's because of the failure of the bureaucracy. It's what Sir said before, the yes culture. So, the planning, the government of India gave them enough time, lockdown 1, 2, 3, 4. So you had enough time to prepare for ventilators, to prepare for the staff, prepare for the everything. But if there's a failure now, and as a law student, somebody comes to you, what is your responsibility? What is going to be your response? So the Honorable Supreme Court has said in many cases, and there are plethora of judgments about right to health. So the right to life, Article 21, very important fundamental right, I would say, includes right to life. And if there's an impact on right to life due to COVID and its implication on individual health, protection by state, and right of health, you can always go to the respective high courts. You can always go to the Honorable Supreme Court under Article 32. Like, for example, you are in UP. UP is doing very well up till now, but if suppose you come across patients in Balrampur, there was a case. I regularly follow the newspapers where the SP of the city has suspended the police officers and the civic officials, but they were putting the body in a garbage van. Now, this is something inhuman. So this is not, again, I'm stressing, not a political fault. This is a fault at the level of the bureaucracy. And what Sir just said, when there's a Disaster Management Act, its implication is enforced. The bureaucracy has a very important role to play. And when the parliament is not there right now, it's adjourned, the bureaucracy is doing in a different fashion. What is left to an individual citizen? What is left to the sufferer? What Sir said. So the sufferer has a right to knock the doors. And how can you do that if people are poor? So people like Dr. Sharma, Professor C.P. Singh Saab, you can set up a legal aid clinic in the university, and we can get lawyers on board, and we can draft petitions to take it to the Honorable High Court under Article 226. So with respect to the issues that I think, which are very crucial for India right now, is one, we have to do some research about the WHO policy and ICMR policy, and whether they're consistent, because the way to fight this pandemic globally is testing. So if there's less testing, you won't be able to trace and track the people. And if you're not able to trace and track, the bureaucracy is, then it would spread. And Sir was right when he said, India is a big country. And, so we need special mechanism. You're speaking about 135 crores. So it's a big population. So what I would suggest, I'm going to give you the points now on which we can assist the poor, the citizens. So you can look for cases where there's a right to life involved vis-a-vis the hospital care. Now, we read in newspapers, apart from Maharashtra, many like UP, like Delhi, especially Delhi, if you take the example, there is no cap on the fees, the professional charges of a private hospital. They are entitled to charge the fees. But as a lawyer, your point should be in this area, in this era of pandemic, there should be a affordable charging system. So the right to life should include right to affordable treatment. Then second issue can be testing. And in testing, when you're doing a petition or you get some cases, you can compare the ICMR WHO policy, then VMA Act. So you can read about it and you can prepare a good petition and you can file a good public interest litigation. Whenever you see that the bureaucracy is not fulfilling the obligations, then dignity to the dead. This is so crucial. And my heart goes out to all the families when I look at various newspaper reports, where there's a mismatch, especially in Delhi. In Bombay today, I was reading a newspaper report in India Today, and there were 2 bodies, who were wrongly claimed. It's so sad. So something should be done about it. And if you come across as a lawyer, because right now we're dealing with the humanitarian opportunity, this is an opportunity for you as a law student also, because you have got a right, you have got an opportunity where you can do something for the society, and don't shy away if you get an opportunity. So coming to that, coming further, how can you do that? You can file a public interest litigation. You can make an association of law students of Lucknow University or Moot Court Association, and you can file a public interest litigation under Article 226. You can, the Supreme Court has dealt with at length about the migrant workers. But if you even now see that the bureaucracy is not giving them, because the government has made provisions, government has allocated funds so that they can get the free food, health facilities. But if you see something has been infringed, you can always go back to the court. Now, when we deal with all these issues, it's very important to understand the law. Now, first of all, I'm going to deal with the European concept. So there's Article 2 of the European Conventions of Human Rights. It contains 2 substantive obligations: the general obligation to protect by law the right to life, and the prohibition of intentional deprivation of life, delimited by a list of exceptions. So when you say intentional, there are 2 very important cases, which I'm going to deal about. One is the MS and BS versus Turkey, and the second one is A versus Turkey. These are 2 very exceptional circumstances. The court, ECHR, European Court of Justice, and European Court of Human Rights, they are the 2 important courts here. The court has accepted that responsibility of the state under substantive limb of Article 2 was engaged as regards the act and omission of healthcare providers, firstly, where an individual patient's life was knowingly put in danger by denial of access to life-saving emergency treatment. This is MS and BS versus Turkey. And the second case was where a systematic or structural dysfunction in hospital services resulted in patient being deprived of access to life-saving emergency treatment, where the authorities knew about or ought to have known about that risk. What just Sir said before. When the Prime Minister said lockdown 1, the authorities were aware this is going to come. And let's take a Delhi model for it, just for 2 minutes. It's not political. We're just speaking about a model where we are seeing every day people are not getting beds, the dead bodies are being confused, and even the dead number of people dead are not being counted properly. The testing. So this judgment, A versus Turkey, will help, because the government, and because Article 2 of the ECHR is very close to Article 21 of the Indian Constitution, and it is where comparatively, if you are aware of Article 21, but Article 21 of the Constitution guarantees protection of life and personal liberty to every citizen. And the Supreme Court has held that the right to live with human dignity enshrined in Article 21 derives from the directive principles of state policy and therefore includes protection of health. And the important cases are Bandhwa Mukti Morcha versus Union of India, State of Punjab versus Mohinder Singh Chawla. Dr. Sharma, you are a constitutional law teacher, so I'm not going to, but you know, you all the students, if you struggle with the cases, you can all come back to Dr. Sharma. I can assist. State of Punjab versus R.L. Bagga, 1998. These are the cases where the Honorable Supreme Court has held, and these are landmark. Supreme Court, Honorable Supreme Court has held, the right to life includes right to health. And now when I go back to Article 2 ECHR and two cases of the European courts, it says it should not be even an intentional deprivation of right to life. So imagine for a second, if you get a case where the Delhi government, for example, any government is not providing health care, not affordable health care, there's no cap on testing fees for poor people, is not providing medicines, is not providing dignity to the dead. You can always refer to these cases, refer to the international law, and you can go to the Honorable Supreme Court, High Court, and you can file a petition requesting for a direction to the executive, because this is your opportunity to do some on a humanitarian scale for our people. Public interest litigations have been filed under Article 21 in response to violation of right to health in the past. Again, important cases: Sheila Barse versus Union of India, Vikram versus State of Bihar, S. Mittal versus State of UP, 1989, E. Kataria versus Union of India. All these cases, and Consumer Education Research Center versus Union of India, 1995, Murli Deora versus Union of India, 2001. So these are the cases where you can look around and you can see that the court will entertain petition A, a public interest litigation. B, you need to be a public spirited person. It's not about politics, it's about you serving the humanitarian objective of being a law student, being a lawyer. Now, another topic which touches my heart is, and which the UK government has done a lot, because it is about the right of prisoners. Now, I'm briefly going to touch upon, like in Delhi University, there's a small college, there's a good college, and it's with the IP University, and they do a lot about the prisoners' right. So you can have opportunity, although the UP government has given payroll to a lot of under trials, but still you can have access to the prison conditions, because prisoners as a group account for more than approximately 500,000 people, like 446,000 is the exact figure, few months back, but 500,000 I would say, persons, out of which 69.4% are under trials. Now, under trial as a law student, again on the law, you would understand, and that, you know, till the time you have not been found guilty, you're not guilty. So even if I'm innocent, but I'm lodged there, and don't forget, prison conditions are overcrowded. Even the prison Prison Stats of India report, PSI 2018, which was released by the National Crime Bureau record, says that the capacity of Indian prisons was 396,223 against the present population of 445,000. So it's an intense work. What are the government regulations across India, across world? 2-meter distancing, wear face masks, have sanitizers. We need to go back to the prisons. We need to ask them. It is not time for the conflict, but you have a duty as a law student to see that people's rights are protected by the bureaucracy, because the government has made regulations. All the rules are there. So this is the second opportunity for you on the humanitarian basis. Now, let's come to the commercial basis, because once, hopefully, this pandemic is going to over, we are going to have good days, we can socialize again. We are all looking forward to it. Then what I perceive and what I'm seeing even right now, I'm getting emails from companies in India, telephone calls from Indian companies from abroad, other countries. There would be a lot of escalation of commercial and civil litigation, and that would be at all the levels. So what I would say, you know, I would advise all the law students, there would be a lot of implication of doctrine of force majeure in the contractual law now. Up till 2019, even I was, you know, nobody anywhere in the world could foresee that this will happen. So what happened, for example, there's an electricity company, has a procurement with the government of India, and they cannot fulfill their obligation. The government cannot fulfill their obligation. What happens? So Nirmala Sitharaman, the Honorable Finance Minister in India, in one of the initial press briefings said that the doctrine is invoked. Now you need to understand why this doctrine is important and why this doctrine will have implications. Because when some of you who would want to be corporate lawyers, who want to draft law, want to draft contracts, some of you who want to be litigation lawyers, there would be a lot of implications. So you need to read a lot about the Indian Contract Act if you want to go into the commercial law. And the implication of reading should be the Indian Contract Act vis-a-vis force majeure. So in India, the law on force majeure is embodied under Section 32 and 53 of the Indian Contract Act. So that is very important. And like what Sir said in the beginning, and Dr. Sharma highlighted, we are looking for a lot of, I would say we are looking for a lot of amendments in law, because once this is all over, the lawmakers, especially in India, in countries like UK, they would come up with new legal provisions for something like this in future. So if suppose something happens in future, how can they, like Professor Balraj Chauhan Saab said, Prime Minister Modi said in before unlocking, Jaan bhi, Jahan bhi, that was the second motto. So the whole focus across, and Sir is right, the whole focus across in the world now is Jaan bhi, Jahan bhi. You have to have a life and a livelihood, because look what the migrant workers, what happened to the poor people? They all had to rush. It was all to India because they were not having the livelihood. And my dear students, in everything there's a risk. And what we learn is you have to risk manage. So, and as a lawyer, your job is to advise the client that there's a risk of the contract, but you have to manage the risk, and how best you can manage the risk for your clients in a commercial dispute. That is so. Coming back to the Section 32 of the Indian Contract Act, I'll just give you a glance. It provides that the contingent contracts to do or not to do anything if an uncertain future event happens cannot be enforced by law unless and until that event has happened. If the event becomes impossible, such contracts becomes void. Now, Section 50 is more important because it says the doctrine of impossibility, which provides that a contract to do an act which after the contract is made becomes impossible or unlawful, or by reason of some event which the could not prevent becomes void when the act becomes impossible or unlawful. Now you've got a contract to do certain thing, but the pandemic happened, everything is locked down, you can't perform a specific performance of the contract. Now here comes the doctrine, and that is what you need to research, you need to learn. Will be a lot of opportunities for you. Some of the notable cases, Taylor versus Caldwell is 1861 England reports. The Supreme Court also in latest judgment, Energy Watchdog versus Central Electricity Regulatory Commission 2017. Very good judgment, I would say. It laid down guidelines with respect to the applicability of Section 32 and 56 of the Contract Act to a contract. So this is very important. Please read that judgment. That will help you, all the students, to understand the concept and why force majeure concept is more important to us today than before. There are other cases also. The Supreme Court in D. Gobind versus Shamji Kalidas, 1961, it recognized the distinction between act of God versus major and force majeure. So the Supreme Court, we are so lucky to have Supreme Court of India. Let's be honest, and it always comes up with. But I would really stress upon the judgment of 2017. The citation is 2017 14 SEC 80. Please read about it. That will give you understanding of the law, because there will be in future about in commercial contracts and rent tenancy contracts, in all the contracts, and in government procurement contracts, in building contracts. And so you need to put these either as a corporate lawyer or as a litigation lawyer. This is important for you. So this is an opportunity for you. You can tell the clients in future, hang on, I can advise you on the risk assessment, how your company can be insulated from any risk. You cannot insulate properly 100%, but you can advise them and protect them to a larger degree. So that's important. Again, the third point is bankruptcy law. This is very important, right? The government has suspended the part of the operation of the act, which is good because you can see why it has been done. But I again stress all the law students to kindly read the bankruptcy law, the Insolvency and Bankruptcy Code 2016, because of the pandemic, the world economy is contracting. The world economy is contracting. What we are seeing, I'm again getting inquiries because there's some companies which has office in China, they have office in Italy, they have office in London. Now, what to do if they can't? They have taken too much loan. How they can restructure, and their main focus is India. So how they can restructure. So, those inquiries, it's very important for you, your career perspective, to read that code, because initially the default limit was 1 lakh. Now it has been raised to 1 crore, if I'm not wrong, and it's changing. It's changing. But I would again stress the students to read more about Section 7, 9, and 10 of the IBC, and because it relates to the initiation of corporate insolvency resolution proceedings. Suspended 6 months subject to COVID-19. That was the first press release. Now the government has said we're going to suspend it for a year. So, but when the things get better, this is something you need to look about, because as the economy contracts, as the creditor and debtor positions becomes worse, as the bad loans becomes worse, the government of India has given another social benefit to the state by 20 lakh crore budget. So, a lot of people will be taking loan, a lot of companies would perform, a lot of companies would not be able to perform. Your job then is to restructure and help them in the business. So please read it. That's a good opportunity for you. Another commercial opportunity is arbitration. Now, this is very, very crucial, because don't forget there are a lot of international arbitrations in London. A lot of international arbitrations are happening in India now. A lot of arbitrations. Recently, Mr. Gopal Subramaniam argued successfully in an arbitration case in Singapore. So Hari Salve is a senior in India, and Hari Salve is a Queen's Counsel in UK. So, global village now. A lot of Indian top QCs, they're lawyers here, they're lawyers in India. Gopal Subramaniam, Mr. Gopal Subramaniam is a lawyer, he can argue in Singapore. So the arbitration, and when you become as a lawyer, when you're a law student, open window. We were very lucky to have teachers like Professor Balraj Chauhan Saab, Professor C.P. Singh Saab. They really helped us to open our window. And you're very lucky because you've got Professor Sharma, Panch Rishi Dev Sharma ji. It's so good. He's giving you the opportunity to do 3-day seminars, even when you're sitting at home. So read about it. This is the time for you as a law student to read, to do something humanitarian first, I would say. That's very important. As a citizen, what Sir said before me, fundamental duty. So it is also your fundamental duty to help and protect your country, and to see the people are being treated fairly as a law student. So humanitarian duty is first, but then once you've done that, read about law. So Contract Act, Insolvency Code, and arbitration. Now coming to arbitration, interim relief provisions under Section 9 of the Arbitration Conciliation Act. Previously, when good days, old days, I'm just saying old days, good days, because these are the normal days. Now, these are lockdown days. So, during arbitration proceedings, a party may approach the tribunal for any interim relief. However, before an arbitral tribunal is formed or after it gives its award, the only forum available for interim relief are the courts. A lot of litigation was there in Delhi High Court, Bombay High Court. So if you want to get into litigation, this is something which is going to go after things are getting normal, because there would be a lot of interim relief provisions, because there's a dispute, the tribunal can't be formed, people will be rushing for interim relief. So that's the logic. So read about it. Read about how the appointment of arbitrator is done, and how under Section 11 of the Act, and how the government, the timeline, which is very crucial. This government has made some very crucial amendments in the Arbitration Act, which are very helpful. Like Section 29A of the Act provides that arbitral awards have to be given within 1 year of completion of proceedings. Now, the Supreme Court on 23rd of March 2020 passed an order extending limitation periods, stating this court has taken suo motu cognizance of the situation arising out of the challenge. So the Supreme Court said, the Honorable Supreme Court, and faced by the country, and the resultant difficulty difficulties being faced by the litigants across the country in filing their petitions, applications, suits, appeals, and all of the proceedings within the period of limitation prescribed under the general law of limitation or under special laws, both central and state. So the Honorable Supreme Court has already extended the period of limitation, but again, Section 29A, there is bit tussle because 29A was inserted by the Arbitration and Conciliation Amendment Act 2015, and it fixes the time period for passing the award to 12 months from the date of reference to the arbitral tribunal. But again, there's a second amendment because the same period can be extendable by another 6 months with the consent of the parties. So read about the Arbitration Act, Section 29A, Section 9, Section 11, because finally, when the good days are back, you would see as even if you're a law intern in a law firm, in a law chief, you can help your senior. And when the students who are going to be passing out now, they can practice Arbitration Act, they can read about Insolvency Law. So this will help you. Now, finally, on the e-filing and case management system. My dear friends, it's very important for all of us to understand the implication, to understand the implication of COVID-19, this pandemic. One thing this has taught all of us is how to find, and this is where I always say, when I give lectures here, how the human race, with the blessings of God, I'm a strong believer in God, and our cultures, I believe in our culture. So how this human race is so enriched by blessings of God that we can reinvent. So the pandemic locked us, but we found a way. We found a way to interconnect, to call each other, to see each other, to give a lecture. And what Professor Chauhan Saab said, in the initial period of lockdown, the courts were closed, but then the lockdown opened. Now you can do e-filing, important cases, how the sufferer can go to the court. So the e-filing is very important. And you all need to know the e-filing system. There are respective e-filing systems in the UP High Court, in the Supreme Court, in the Delhi High Court, and also the future in India would be a case management system. So because I'm coming back to my university and I want to share something what I've learned here. Here we have got a case management system. So for example, you've got 700 cases and you're doing those cases. Now there's a case management system called LEAP, for example. I'm just giving you one example. There are many case management systems. So we scan all the papers in the LEAP, all the petitions, and it's all stored on the cloud. And I can access all the papers from my laptop. So this is something which is, and there's a new system which is in Delhi, which is happening. So all of you should be now starting to work on an e-filing system basis. You can create your own e-cloud account. You can, whatever petitions you're doing, you can scan and send it there. So even if you are in a lockdown tomorrow, you've got a client, you don't have to go to the office and you have to file a petition. You can file it, copy, paste from the cloud and send it to the court. So this is the future. Now, while we were discussing about the legal opportunities, I also want to share what has happened here from the global perspective. So what has happened here in UK? In UK, the government has passed a Coronavirus Act 20. Very important because, like in India, the Disaster Management Act is there. In UK, the Coronavirus Act 2020 is there. So the Parliament, before, obviously it's working virtually, what Sir said, which is right, it's working virtually. But before it was suspended, the first lockdown, they passed this act. And this is very crucial because Section 87, the first Section 1 says, defines the coronavirus. Section 87 says the commencement. So it commences now. And if you go through the act, there are very special provisions. I can take you quickly through it. Like there are emergency registration of health professionals. This is what the government planned. Because in UK, I can give you a UK perspective and the European perspective. So in UK, the health is all funded by the government. It is by the National Health Service. And so all of us gets free health. Nobody has to pay anything and everybody is treated equally. So, but because the government has to do the lockdown and they had to get more doctors, more hospitals, they built up about 6-7 hospitals every week, and they converted like big stores, big halls into makeshift hospitals. And what exactly Balraj Chauhan Sahab said that in his lecture today, that the UK that the government in India also got a lot of time. The Prime Minister gave them a lot of time. The time was to prepare so that the bureaucracy can prepare the ventilators, the beds, and everything. So what happened here, because the NHS is funded, is for everybody, the government passed this legislation. In the legislation, there was emergency registration of health professionals so that we do not have shortage of doctors, nurses. So even the retired doctors are called into. This is something what we can do in India, what we can, what we can ask the retired doctors to work, but there should be a process. The government can invite them, like especially in Delhi, in Bombay, where there's shortage of doctors now. We are lucky in UP, there's no shortage as such now. Then there is temporary registration of social workers. So the social workers were called into so that they can go, they can take care of the elder people, the children. Then there was emergency volunteers. There was registration of them. Mental health and mental capacity. Then NHS and local authority care support. So there were a number of provisions which was in this act. You can read about it. And the most important part was about, because here sir, when you said about the response, obviously India being such a big country, we cannot give the financial support to everybody because it's a huge country, and sir is absolutely right. But here in UK, because of the population and everything, government, and we are so grateful here to Mr. Rishi Sunak, who's the Chancellor, who's the Finance Minister, we call him Chancellor here. He gave financial support to everybody. So we have got 3 categories here, like people who are working in a company, they're private company owners, they get salary for their staff. It's called a furlough. So you get 80% salary for the staff. And this is going till October. The people who are self-employed, they get their 3 months profit by the government. So the government computes, and how they compute the 3-month profit is they look at the last 3 years tax returns. So which encourage people to file tax returns on time and be more compliant. So the government has given 80% profit of the 3 months to individual, and people who are not working, who can't get jobs or be laid off, they're getting the universal income. It's called universal benefit. So they get a good amount of money, and plus the rents are also paid by the government for those people. You don't have on the health. So in a way, Rishi Sunak, and again for the companies, he has given grants like £10,000, £25,000 for the companies, and he has given everybody at 2.5% rate interest. So Nirmala Sitharaman, the policy what she's trying to bring is a good policy. If the banks support her, because this is exactly what Rishi Sunak did here before, and the banks are lending like £50,000. You can take, any company can take a loan of £50,000, which is interest free for a year, but from year 2 to 6, you have to pay installment, and it's roughly 2.5%. So it's very helpful because everybody has got some money, and so the economy won't go flat. So Rishi Sunak, I would say, has done very good, and we all should be proud because he's of Indian origin, and he's a very nice gentleman. With respect to the Coronavirus Act, government here, this act, the expiry is 2 years, it's Section 89. So they have planned for 2 years, but there's a caveat here, Section 98, which is very important, the 6 months parliamentary review. So even though the act is passed, the act is for 2 years, the act expires in 2 years, the Section 98 is important, and if I may read with your permission, sir. Section 98, 6 months parliamentary review. If the House of Commons rejects a motion in the form set out in subsection 2, moved in accordance with subsection 3, a Minister of the Crown must exercise the power conferred by Section 91 so as to ensure that relevant temporary provisions expire not later than the end of the period of 21 days, beginning with the day on which the rejection takes place. So which means the parliamentary review here, and the parliament can review the act because this is a temporary act. So this is what is happening in UK. Although the number of people have died, sir, but still they have done a phenomenal job. And right, sir, the number of cases like in India is increasing. It will increase because we have to be realistic. It is because it's a very big population we are speaking about. We're not speaking about a small population. We're not speaking about Sweden. We are speaking about India, which is so massive. So we don't need to be depressed about it. We need to be positive about it. And as a law student, I would suggest you're my colleagues and you're my brothers and sisters because we are from the same college. Don't feel down. Be positive. The government is doing its best. Be positive. This is not the time to confront. But where the executive, the bureaucracy fails, please, it is your duty then as a law student to be a custodian for the individual's right. If the dignity of the dead is not preserved, we need to the court. The class of people become sufferer. And as we discussed, you've got a lot of opportunities for commercial. So don't feel, there would be, because the media sometimes tend to report in a negative manner. They would say there would be jobs, but I would say,
we have our own Fox News network here.
I know, but Dr. Sharma, I would say, what PM Modi said, Atmanirbhar Bharat, that's important. In UK, I would say, we are Atmanirbhar. We have got a company, for example, I've got a law firm, I'm director of a law firm. We have got government contracts, so we work with the legal aid agency also, because here in crime and public law, the government funds, the legal aid agency funds for poor and destitute people. And it's very good rate. For crime, you get very good rates for the legal aid. They take care of its citizens. But it's Atmanirbhar because you set up a company, then you employ other people, and then 10 people work in the law firm, then it expands. So, I'm giving an example. So I think as a lawyer, you are Atmanirbhar from the day one. You go to the courts. So don't worry. There will be a lot of opportunities, and that is why on the positive note, I've spoken about the contractual aspect. There will be a lot of opportunities for you to even tell the landlord-tenant cases, and craft the contract in such a way so that you can insulate the tenant, you can insulate the landlord, you can also, arbitration, insolvency codes, and other laws, criminal law, there would be, unfortunately, some cases in criminal law also. So, there always are. I would say be positive and keep reading. This is your time to read. Keep researching, and please take part in your duty as a citizen of the country. If you see a fundamental right being infringed, please take the view. Take the view, take action, and we'll support you. Thank you. Thank you very much.
Thank you,
Dr. Sharma, I should say, I'm again feeling so humbled because I'm speaking in front of Professor Balraj Chauhan Sahab and Professor C.P. Singh Sahab. I was thinking, I don't know how I would speak, because I can speak in an international forum.
Excellent, Harjot. Really, feast.
No, sir.
Really, I mean it. Everybody will say, very well done. Very well done.
Thank you, sir. Sir, but आपके सामने बोलने में sir बड़ा
Lucknow University team for inviting you. Well begun is half done. Excellent.
No, thank you, sir. Thank you, sir.
सारा आशीर्वाद आपके लिए. I am
thank you, sir.
Really a real professional in front of me.
No. Thank you, sir. Thank you, sir. Thank you, sir.
Over to Sharma, please.
Oh, thank you, Arjun. It's very enriching for us, not only for our participant, but I individually also learned a lot, because academics is a wonderful profession, but it lacks in one point, that we lack the practicality of law. And I do believe that until and unless a lawyer do not reach towards an academics, and academics do not reach towards a lawyer, we can never become a good lawyer, neither can become a good teacher. So I believe that the beauty of law teaching is that when you merge the theory with the practice, and there is no better person for us who can merge the theory with practice like you did. The way you have compiled commercial law, family law, constitutional law, international politics, international arena, the British system, the NHS, I was really wondering about how NHS has responded to UK, because we are reading a lot of reports about that recently. Like yesterday only, the New York Times put a full OPED page on NHS system. So that is one area on which we were very much looking forward. And you are really, Britain is really lucky that it is run by at least some part of the British COVID policy is run by a female. We are missing that. So only Nirmala Sitharaman is there, and we know how women are responding to this COVID, because how New Zealand has responded, that's mesmerizing. So I don't know what Americans would be thinking about the defeat of Hillary Clinton right now, but they might be missing about it. Anyways, it was very enriching for us. There are lots of questions, but there is one question which was coming from the faculty members, some of the faculty members, which is about that. This is a question from a faculty member from Political Science Department, I think from Jadavpur University. I was not able to get the name of that
No
person.
problem. Yeah.
This question is like, do you think that EU dynamics will change after this COVID? And her question is a long question. It is linked with how French Prime Minister has responded during COVID and post-COVID, that if EU is not able to help France and other countries, then how EU would respond. I know after Brexit, there would be certain anonymities between UK and Europe, but what is your neutral point of view?
Dr. Sharma, please excuse me.
Yes, sure, sir.
I have to join my meeting, Criminal Law Reforms Committee meeting. So I would like to say goodbye to all of you.
Thank you, sir.
Thank you very much.
Thank you so much,
for
sir.
providing me this wonderful opportunity. So nice of you. Thank you. Thank you, CP. Thank you, Sharma. We will meet Harjot.
Thank you, sir. Yes, sir. Yes, sir.
Yeah, coming back to the question.
Yes.
What she was meant to ask is, do you think that EU dynamics will change? Will it be
Yes.
more China-centric or less China-centric, or it will be more conservative or more widened in its scope after COVID?
I think that's a very good question, Dr. Sharma, because I personally feel, coming to the Europe, I think Europe has responded very well, because again, Italy, again in France, the government has given a lot of financial support. So, for example, you've spoken about France. President Macron did very well, because he gave all the bills, the electricity utility bills, given to the citizens by the government. So 3 months, everything was suspended. That was very good. Number two, I think France has controlled the numbers also. So their numbers are not rising. If you, to John Hopkins University website and the WHO, they're doing well. Even Italy has done well now. And the government has really supported. But in terms of the financial support, what the UK has done, that's phenomenal. You know, they have given it to all its citizens, all people, even people who are asylum seekers, and anybody who's homeless was homed in a hotel for 3 months at the government expense. People who are vulnerable, who are shielded, there was a lot of people who are vulnerable. And this is what something we can do in India also. You know, like they are saying, protect the vulnerable. But how would you protect? You need to form citizen bubbles. And what happened here? There was a volunteer army which was helping the government in, you know, free food boxes, in Dr. Sharma, boxes like this big, free of cost, by the government to all its citizens. So, but again, I'm stressing this can happen in UK because of the size of the population in India. It would be very difficult. Coming back to the dynamic point, I think a lot of dynamics has already changed. In US, there's a case against China. In US, already somebody has filed a claim against China of big damages, more than $1 trillion. Now we have to see how the US court would react. There would be something happening here in UK also, because UK and US, two jurisdictions which can really, you know, like the UK, for example, London High Court has got a power to issue freezing injunctions and to basically, you know, freeze all the accounts. But, you know, again, when you speak about China, there are a lot of geopolitical, you know, strategies. I don't know whether it would be a government to government level but legally there would be something. I've also heard that some people are planning to file a case in the ICC, which is
Yeah.
International Criminal Court, against the Chinese government's negligence. They're not saying it's so, we have to see how these things, but certainly this will be for next at least 2 to 3 years. This will be a very big legal arguments. There would be a lot of good legal arguments, and it would impact the change in the international law.
So that leads to another question by Mr. Aniket Mishra.
Yes.
What he wants to ask is, as in UK, a person pays 60% of the tax, which includes its health, education, etc. expenses. These lead to less amount of expenses borne by a person. Don't you think that it should be implemented in India too? Do you think heavy taxation would help?
To be really fair, I'm not a tax lawyer, but I can tell you, people don't pay 60% tax. Again, the bracket is maximum is 40%, and then for corporate taxation is very less. I think it's 20 or 19%. But again, I'm not a tax lawyer. But we all contribute towards the national insurance contribution. So national insurance, but still, Dr. Sharma, there are a lot of people who don't pay tax and they're poor. So it is a collective responsibility of all the citizens here that when we pay taxes, we take care of everybody. That's why the health is free, the education is free. Education is completely free till class 10, class 12, sorry, A levels. We call it A levels. Now, also, while I'm responding to this, about Brexit, what you said, and, the European response, I think even after Brexit, there won't be any animosity. And the whole European response is very pro-human, because I think Europe learned a lot post-pandemic first and the World War I and II. And I think now the world is going to learn, because now I think what India will have, like India, I love India, India is my country. India, we have the health budget is 1.2% or 2% of the GDP. I think that's too less. So we should have, even though we have to include a cess in the percentage of the, the tax or the petrol or something, there should be a health budget. The health budget should be at least 4 to 5% of the GDP. Like NHS has one of the biggest budgets in the world. Now, unfortunately, what's happening in India, we have taken a model of US. And because, we are based banking on the private and the insurance, and we're also banking on the state medical facilities. Now, unfortunately, what I see that after this pandemic, the government will increase the spending in the national health infrastructure. They have done a lot, but more need to be done.
And we should compare it with the defense spending that India does. Just because of our nationalism, do not let us speak on that. That is also one gray area.
Yes.
That is another question.
I would avoid that. But I would stress, and there should be some public interest litigation learning from this experience, because we have seen one very important thing. Sorry, Dr. Sharma. One very important thing we have seen this time is that the private sector has failed us. There is overcharging. I'm hearing people being charged 3 lakh rupees per day.
Yeah.
And imagine somebody whose family member is going to die. And so, here we don't have to pay anything, not even medicines in the hospital. So in Europe, when we speak about Europe, the whole Europe has got a free health system, more or less. It's very good. Like in Germany, it's so good. You don't have to pay. So, I think we should, as a law student, this is something that we should positively contribute. Pressurize the government, make public debate that we should spend more on health.
Until and unless it does not become an agenda in election, that health is the most important thing. It won't change.
Yes.
Anyway, there is a question by Nupur Katiyar. Nupur is, if she is the same Nupur Katiyar, she is a very bright student of our law honors. She is asking a question that on humanitarian aspect, what are the chances of an application to a claim of a vaccine or a medicine as an intellectual property for an individual person whenever that vaccine or medicine is made, who is rejected on mass benefit? if somebody is asking a claim on a medicine or a vaccine whenever it would be discovered, what would be an individual's claim, like in India or anywhere else?
It depends. It depends a lot on the implication of the intellectual property rights and laws across the globe. But we are lucky because the countries like Oxford, which is leading the research, Prime Minister Boris Johnson said, once we get the vaccine, we are going to share it with the world. United States has already paid a good amount of money to the company which has been licensed here. Now, again, the government of India will surely get the vaccine from UK. That won't be a problem. The government,
yes.
And then, Dr. Sharma, it's very important because then it becomes responsibility of the government of India or the government of, whichever government. Suppose we are speaking about Bangladesh, then government of Bangladesh. So in this case, Indian government to give the vaccine to all the citizens at a very nominal charge. Now, what you said at the conclusion of my speech. Also, one more thing I wanted to touch upon. You said, as an academic and the practical aspect, I think here it would be guided by jurists and senior academic professors like yourself, like Professor C.P. Singh Saab, Professor Balraj Chauhan Saab, because, don't forget in US, and there's an example, one of the senior Supreme Court judges was a former lecturer in the university. So she became a Supreme Court judge. And there's even a movie in Netflix on her.
Yeah.
So, I think in India also, to evolve better, we need to encourage even the practitioners to be opted to the High Court, because only then you can expect the high quality, legislation to be passed in the parliament, because, you need more and more law professors also to be part of the parliamentary law panels, so I would say no, for the question that, let's be positive. And I don't think people will make money on this.
Yeah, and to add on a point on with what you have said, like the vaccine that Oxford University is manufacturing, it is manufacturing with Serum Institute, and Serum Institute is in India, which is the largest manufacturer of vaccines.
Yes.
So for any mass production, the world has to be dependent upon India, luckily. So I do not think that the mass production of vaccines it can be originated at anywhere, but mass production is dependent because the three largest manufacturers of vaccines are in India only. And that is one plan. Another thing is that the government of India is also contributing to this global vaccine creation program. That's also one very positive news in this regard.
I just want to update, the mass production, the Oxford has entered into a contract with a company in UK for mass production, which is AstraZeneca. I don't know whether AstraZeneca has a contract with Serum, but it looks like they have a contract.
It has a contract with Serum. Serum is developing the base on which this vaccine would be preserved.
Yes.
And that base is the most important element, because you just put a small molecular RNA on that, and that's what they are searching. So
but I would say to law students that whoever develops a vaccine on the intellectual property right, I don't think it won't be for the government won't be able to argue that once the government has bought the vaccines, that the IPR issue and, they won't give it to the citizens. So I think for India, we are lucky enough. India is a very powerful country in the world. And once we get the vaccine, it should be given to all the citizens, free of cost.
There's a question from Vivek Kumar that the point you have raised recently, I think we have covered it, that there is very expensive treatment modules in India in certain private hospitals. That's really abysmal, to say the least. And I hope government and legislatures and judiciary shall respond on that, because this is not a trying to earn money.
No. Dr. Sharma, just to update you, Panchrishi ji, we are planning a public interest litigation. So again, there are a group of 6 law students from one of the IP universities colleges, and they're working on a project with us. And we are planning series of PILs in Delhi, Lucknow, and probably in Bombay, where we are arguing that the medical expenses should be capped during the pandemic. And under the Disaster Management Act, really the government has got power to cap it. If the bureaucracy doesn't want to cap it, Maharashtra has capped it, 10,000 per day for hospital beds. You know, why in Delhi they're charging so much? You know, even in Lucknow, I've heard Medanta and Sahara, they're charging more than 1 lakh rupees a day. So, you know, this, I would say this is inhuman. You know, this is inhuman. And you know, so we are hoping that there should be public interest litigations. What I encourage the students from my university, you can contact Dr. Sharma, Ayush, and under the guidance of Professor C.P. Singh Saab, you know, and if you come up with a plan with some research, we will fund a public interest litigation and we'll take the public interest litigation to the courts here.
I think that is really important for all of the students, that if somebody wants to, and I'm sure because so many of them are my students, so many of them are looking forward to an opportunity like this to interact with you and to learn from you, and there would be no better opportunity for you like this.
It's
so
my honor.
I think they will be listening to it and they'll be really looking forward to it. We'll be covering that area after this webinar is over, because I'm sure I'll be flooded with questions regarding joining your firm or working.
You're more than welcome. You're more than welcome. And Dr. Sharma, if you can set up a legal aid clinic sort of thing there.
We have a very vibrant legal aid clinic.
Wow.
In our campus.
Brilliant.
That's working really, really well.
Brilliant.
Anurag sir is monitoring that, coordinating that clinic, and it's really working wonderfully well. So I'm sure they'll get in touch with you. There's one question. Yes. Okay. Okay, it's about what kind of a liability will fix on China? Will it be a strict liability or absolute liability? What will be the responsibility of China with regard to the virus outbreak? And in case of any future virus to be used as a biological weapon by any other country?
You know, again, this is a very diplomatic question. And in terms of the liability, I think, first of all, we have to make a joint claim. I think joint, you know, there should be a class action. There should be a class action either in the court of Delhi or any court. And you know, a lot of people are doing research right now that whether there can be a class action making, you know, the government of China as a party. And again, you know, you have to understand it's a very complicated area and complex area of law, because there would be whether you have to seek permission from the government of India. So the one thing can be you can make a representation to the government of India and seek a direction that the government of India should claim compensation on behalf of the citizens. The second argument can be you can make a claim, but then, like in US, the law is clear. There's a particular act. They can make a claim, but it depends how the Indian courts would react and how the government will react. So, you know, I think it's a diplomatic thing. I think at the international level, there would be liability. There's a lot of political debates right now, but once this is all over, there would be legal arguments. And I'm sure, because I've heard that a few people are making representations to the ICC also, which is the International Criminal Court. So it depends, you know, the UK, there's some people who are claiming in UK courts, and I think we should try to claim once this lockdown is over and, you know, sit together, get everything together, because you have to prove why China was negligent. But although it's an international law issue, you know, we have to tread carefully, and, you know, we have to see what the government policy would be.
Okay, thank you so much. I think we have covered most of the questions. We have already crossed our time limit by half an hour. We have already taken much of your precious time. Thank you so much, Harjotji. It's an honor, it's a privilege, it's a complete pleasure for us to bring you in this digital platform. It makes us feel connected, it makes us closer, and nothing could be more important than this for the university and our interaction. Thank you, Harjotji. It's wonderful listening to you. It's wonderful interacting with you, and I'm sure Lucknow University will conduct more of these sessions with you, and will actually take every bit of your experience and utilize it for our students. That kind of selfishness is there.
No, I'm part of the university. I'm always there. I'm always there at Lucknow University. That's my uni.
Thank you.
So
Thank you.
Thank you very much. Thank you.
Yes, sir. CP, sir.
Thank you very much, Sergio. Thank you very much.
Thank you, sir. Thank you very much, sir, for having me, sir. Thank you very much, sir.
So with this, we'll conclude the session for today. Please don't forget that there is a very important session coming up tomorrow. Tomorrow's session is about how the theme of the conference webinar is set. Now, how we'll tune the webinar. And to tune the webinar on this area, we have two important areas. One is the vulnerables, like migrants, like workers, like women in a household. So that's why we have brought two wonderful females. One is a faculty from Delhi University. She will be covering the issue of migrant laborers. She is an associate professor in Delhi University. She is Dr. Shikha Kambose. She'll be covering the issue of how migrant laborers and their crisis in India has taken up, how the country shall respond to it, what are the legal, constitutional, and other executive options. And another one speaker which is coming up next for you is Dr. Naomi Shirin. She is an assistant professor in Asia's University for Women in Bangladesh, which is #1 university in Bangladesh. She'll be covering the areas regarding the domestic violence that is occurring during the COVID situation in Bangladesh, India, and South Asia, which is a very, very prominent issue because that is one area which is ignored. So we are covering two themes in theme tuning. One is vulnerables, which include migrant laborers, women, household, and what about their situation in this Law 2.0? Is Law 2.0 going to shape any new reforms for them, and what are the challenges in front of us? So please tune in with us at 3 p.m. sharp, and we'll be covering these two sessions back to back, probably first with Naomi on women issue and then with Shikha ji on migrant laborers issue. So I request all of you to be there. I hope you got some point of views on this webinar. As I could see the poll that you have just submitted, I got 80% response that it is 10 on 10. So if it is somewhere around 10 or 9, we are really honored. We are really overwhelmed, all of you. All of the participants, I've tried to take up all of the questions as much as I can. Some of the questions I have not taken. Some of them are repeated. Some of them I missed. So I apologize on my behalf for that. And please don't mind. Please do ask questions as much as you can. And thank you. You have been a lovely audience. You have given enough time to our speakers, and I'm sure that you have been overwhelmed. So on this note, I say bye-bye to all of you. Thank you, Arjot. Thank you, CP sir.
Thank you, Jai Hind.
Thank you very much. Thank you, Ayush, Nishant, all the LUMA members. Thank you, all of you. And we'll see you tomorrow, 3 p.m. Stay healthy, stay safe, stay indoors. Thank you, Arjot.
Thank you. Thank you. Jai Hind.
Only LUMA members will stay. Whoever is a LUMA member.